organized by Dr. N.R. Madhava, Chair on Legal Education of MGCL, in association with Commons Initiative, Nodal Office, Christ deemed to be University, and Save Wetlands International Movement, on the topic Governance, Environmental Sustainability, and the Developmental Tradeoffs by none other than Adv.Prashant Bhushan. To begin the event, let us invoke blessings with a prayer. I request everyone to rise for the prayer.
ലോകം മുഴുവൻ സുഖം പകരാനായി സ്നേഹദീപമേ മിഴി തുറക്കൂ. ലോകം മുഴുവൻ സുഖം പകരാനായി സ്നേഹദീപമേ മിഴി തുറക്കൂ. കഥന നിവാരണ കനിവിന്നുറവേ, കാട്ടിൻ നടുവിൽ വഴി തെളിക്കൂ. ലോകം മുഴുവൻ സുഖം പകരാനായി സ്നേഹദീപമേ മിഴി തുറക്കൂ.
Thank you, Feba and Prisha. In remembrance of the lives lost of our brothers and sisters in the Wayanad landslides, let us remain silent for a few minutes. Thank you, everyone. Please be seated. Now, I would like to invite Professor Dr. John P.C., beloved principal of Mar Gregorios College of Law, to deliver the welcome address.
President of the meeting, Reverend Father Advocate Joseph Van Manath, Bursar Father Adarsh Kumbalat, the chief guest of the day, Adv.Prashant Bhushan, the guests accompanied Mr. Prashant Bhushan, dear colleagues and students. This is the 7th edition of Mar Gregorios Public Law Lectures. Most Reverend Benedict Mar Gregorios was a philanthropist and was the first principal of Mar Ivanios College, Thiruvananthapuram, in whose name this college is dedicated. In 2015, the College Council decided to hold every year a public law lecture to commemorate the legacy of Most Reverend Benedict Mar Gregorios. The first lecture was delivered by Dr. Cornelis Flinderman, Professor of Law, Utrecht University, Holland, and was a member of the Human Rights Commission of UN. And after that, Justice Kurian Joseph of the Supreme Court, Professor Ranbir Singh, Vice Chancellor, Nalsar, Hyderabad, Professor Paranjit Jaswal, Vice Chancellor, National Law University, New Delhi, Justice Muhammad Mushtaq of the Kerala High Court, Justice Jyoti Mani of the Madras High Court were delivered lectures in various topics. This year we have selected environmental law as a subject for our lecture. Governance, environmental sustainability, and the developmental trade-offs as the subject for this lecture. This topic is a burning topic in the scenario of recent landslides occurred in Wayanad. More than 400 people died and acres of cultivated land washed away. The entire eastern region of Kerala, as you all know, is susceptible to landslides, which is located in Western Ghats. Whether this is a man-made disaster or a nature's fury, it remains as the importance of protecting our environment. In the scenario, I would like to restate the wordings in the reply letter written by Red Indian Chief to the President of America, who seeks to buy the property of the Red Indians for developmental works. I quote, "The sale, if happened, will nullify many facets of environment, the sacredness of the land, the sparkle of water, the freshness of the air, the midst of dark woods, the music of the mines, the songs of the humming insects, and the fragrance of the flowers. Unquote. This letter ended with a question. Will anybody depart from possessing such environmental wonders? Will anybody depart from possessing such environmental beauties? This shows the interrelationship and the interdependency of nature and human race. This shows the need for protecting our environment. Remember, we are not the owners of this property. We are only the trustees of this property, and we have to preserve this property, this earth, for the benefit of the future generations also. Today we have with us a person who declared war against corruption in public life and human rights violations and for the protection of environment, Advocate Prashant Bhushan. Mr. Bhushan completed his master's from Princeton University, United States, and the law degree from Allahabad University. And it is understood that he joined for BTech at IIT Madras. And without completing the BTech, he joined for law degree course at Allahabad University, I think. We lost a technocrat, but at the same time, we are gifted with a philanthropist and a person and a warrior against corruption and a warrior against human rights violations and a soldier for preserving judicial accountability and a soldier for environmental protection. Sir, on behalf of Mar Gregorios College of Law, I extend you a heartfelt welcome to this institution and for this lecture. I welcome the guests accompanied Professor Mr. Bhushan, Sri Thomas Lawrence. Sri Thomas Lawrence is the CEO of Save Wetlands International Movement. He is an alumni member of the Mar Gregorios College. Then Advocate Varun G. Nair. Dr. Jacob Vadakumjeri. And Sri Godwin, the Nodal Officer of Christ University in Thiruvananthapuram. I welcome our Director, Father Joseph Venmanath, Bursar, Father Adarsh Kumbalath, Academic Advisor, Professor Thomas Hooty, Vice Principals, Professor Usha Kumari, Professor Ramachandran Nair to this function. I welcome my colleagues and my dear students to this program. Thank you very much.
Thank you, sir, for the warm welcome and setting the tone for today's event. Now, it's my privilege to invite Father Advocate Joseph Venmanath, Director, Mar Gregorios College of Law, to deliver the presidential note.
Chief guest of the day, Adv.Prashant Bhushan, our principal, Father Adarsh, academic advisor, dear guests from various organizations, dear colleagues, and my dear students. This is another historic day in the history of Mar Gregorios College of Law. We are having an eminent personality with us. Some of his specialities have been enumerated by our principal in his welcome address. We know him through social media, through media, newspapers, and through environmental activists. He has been a beacon light of human rights. He is a philanthropist and an apt person to speak on environmental protection, etc. There is an important word in the preamble of the Constitution. We often forget that important word. Along with justice, liberty, equality, we have the word fraternity. Actually, I think Advocate Prashant Bhushan is the man who understood the meaning of the word fraternity in deep lines. It is because of the deep-rooted fraternity in him. He is standing for the downtrodden, the voiceless, and also for the environment. Dear sir, we are living in the galaxy of Milky Way. We have n number of galaxies, different galaxies available in the universe. I would say even the galaxies are thankful to you because of your activities, because of your initiative for protecting the environment. We cannot count or we cannot measure the enormity of this universe. Even our own galaxy is wide, almost a lakh light years. You know the extent of light years. We cannot even imagine the length and also the breadth. And the universe is very vast. And each and every organism, except some disease-causing germs, are useful for humanity and universe. And Advocate Prashant Bhushan is a man who understood this truth of the nature, and he is there. And we have a beautiful topic today: governance, environmental sustainability, and developmental trade-offs. So immediately, in order to understand the meaning of the topic itself, I was searching, and then I ended up the meaning of the word trade-offs. A trade-off is a kind of compromise that involves giving up something in return for getting something else. So often, for the sake of development or in the name of development, as it is already mentioned by our principal, the marvels of the nature, the wonders of the nature, the beautiful beauties of the nature are just trampled upon. Every day, we see it with our own eyes. Ponds are being filled with soil for constructing new and new buildings. Trees are cut down. When I was in Pune, for cutting down each tree, a Pune resident needs the permission of the local self-government authority. In Kerala, we don't have any such a restriction. Because of the enormity or number of trees available in India, in Kerala, we cut down trees without any restriction. We are actually destroying ourselves. And I would say we are fortunate enough to live with a man with the stature of Advocate Prashant Bhushan. He is there to help us, to help the coming generations. And this morning I was speaking to a doctor, and a doctor may be conducting thousands and thousands of surgeries, and he is gathering knowledge by doing each day, each surgery. The knowledge acquired by a particular doctor can end with his lifetime, his lifespan. But a futuristic judgment of the court will live generations after generations. And actually, the real work and worth of Advocate Prashant Bhushan will be enjoyed by the generations which are coming. Not only the present generations, and the coming generations will also benefit out of the work and the determination of Advocate Prashant Bhushan. We take this as an institution, a young budding institution. GREGORIOS College of Law is very happy to have you, sir, with us this morning. And we are with you. Continue your work. Thank you.
Thank you, Father, for your inspiring words. Ladies and gentlemen, we now come to the highlight of today's event. It's an honor to introduce introduce our esteemed speaker, Adv.Prashant Bhushan, advocate on record at the Honorable Supreme Court of India. I humbly invite Sir to deliver the lecture.
Thank you very much. It's indeed a great pleasure and a great honor for me to be invited to speak to you, and I'm really happy to see so many young women here who are studying tickets already, who are studying law and aspiring to be lawyers. I'm grateful to the principal and to the management of this fine institution for inviting me. And I'm a little overwhelmed by the kind words said to me, said about me by Father Venmanath. I think he went a little overboard in his. You see, I see myself as an ordinary, normal person who has, and this is something that I want you all to imbibe as well, who has tried to see what is happening in our society, in our country, and have tried to understand sort of a whole range of major issues that are before us. So, in that journey of trying to understand what is happening in our society and in our country, when I come across some injustice that I see, or something wrong that I feel is happening, or some wrong policies that are being followed, I try and raise my voice against that. I try and raise my voice, if possible, in the courts also, and to the extent that I can outside the courts also. And that is what, see, a lawyer is not merely the agent of some client who comes to you. A lawyer is considered to be a civilized warrior for justice. So you are all going to be civilized warriors for justice. And you must never forget that you are not merely an agent of your client. And I have always adopted this practice, though it's not a practice which most lawyers adopt, that I do not take up a case of a person who I feel is not morally on the right side. It's only when I feel that this person is justified in whatever he has done, only then I take up his case. Now, of course, what is justified or not justified may be a subjective perception. But I have always been of the view that I do not want to lend my voice or whatever influence I have within the court or outside the court to advocate the cause of somebody that I feel is not morally in the right. I know that most lawyers are told, do not judge your client. That is for the judge to decide. You have to take up the case of anybody who comes to you and plead his case or advocate his case in the best possible way. I know that that is the advice that is normally given to lawyers. I just wanted to tell you I am not sure as to what is the right advice to follow, but I am telling you what I follow. The other thing that a lawyer should, before I go into this issue of environment, you see, if you ask this question, How many people are being able to get justice through this judicial system that we have in this country today? The honest answer to that would be very few, not more than few, 3, 4, 5%. And the reason for that is that the vast majority of the people who have suffered some injustice are unable to approach the courts at all because they cannot afford the fees of any lawyer. Therefore, they are not able to access the system at all. Even if they have been falsely charged by the police for some offense, they are unable to defend themselves, effectively defend themselves. They are unable to even secure bail for themselves. And therefore, the vast majority of people who are today in jails are not convicts. They are just under trials or under investigation who have merely been accused of a crime. And sometimes they stay in jail for years altogether. It is the job of, in my view, it is the job of any lawyer to try and help these people in whatever way one can. One can do it through public interest litigation. Also, the Supreme Court has taken up this issue in several cases and said that those under trials who have undergone more than half of the maximum imprisonment that can be imposed on them for the alleged crime, they have to be released forthwith. You can also take it up individually if you can. Of course, it's difficult because these people are all languishing in jails. But I'm just giving you this example that today, vast majority of the people can't access the judicial system. Those who can access it, who have the money to pay a lawyer, are either suffering delays in the court because their cases don't come to be decided. And even when their cases come to be decided, they are often wrongly decided because of the incompetence of the lawyer, incompetence of the judge, or sometimes even corruption on the part of the judge. And the result is that very, very few people are able to get justice in a time-bound manner in our judicial system. Now, as lawyers, as any public-spirited citizen, especially a lawyer, we should feel a duty to try and help to fix the system, to reform the system, so that people can effectively get justice through the system. Our job is not to just use this profession to make money. Our job is to ensure that the system of justice works and people get justice. Now, how do we fix this system? As I said, one problem is that most people can't access lawyers, can't access the courts because they can't pay lawyers. The solution to that was found to some extent in this Gram Nyayalaya Act, which came in 2010, which provides for a simplified system of courts called Gram Nyayalayas, which would be set up at the sub-tehsil level, at the ward level, and which would also travel to the villages. These courts are not required to rigidly follow the code of civil procedure or the code of criminal procedure. They can adopt any procedure which is consistent with the principles of natural justice. Now, unfortunately, even 14 years from the act, very few Gram Nyayalayas have been set up, and very, very few are functional. Today, we should have had more than 5,000 Gram Nyayalayas across the country. But the fact is that we have less than 250. Not even 5% of the Gram Nyayalayas in the country are functional. That to some extent would have solved the problem of access, because at least in these Gram Nyayalayas for ordinary cases, people would have had access. without even the help of lawyers, because these were simplified courts, not rigidly following. One of the reasons why people need lawyers is because of the complex nature of the procedure. CPC, CRPC is so complicated that lay people cannot negotiate this procedure. There is no reason for these very complicated procedures, especially in these, or to decide these ordinary cases. When I was in the US, there used to be a program called People's Court. I don't know, maybe it is still running. So some television channel had got a retired judge of California to preside as a judge to decide actual cases which had been taken to court but which were now withdrawn and agreed by the parties to be decided by this retired judge. Now he used to call both parties with their documents and their witnesses, and he would ask the plaintiff, okay, what is your grievance? Then he would ask the defendant, okay, what do you have to say? And if he felt that there was any dispute of fact, he would ask the plaintiff, do you have any document or any witness to prove this fact? He would ask the defendant what he has to say. He would allow the defendant to even cross-examine the plaintiff or his witness, etc., then and there. And in less than half an hour, he used to hear the whole case and decide the whole case. So I saw that program maybe 20-25 times. It used to be a 1.5 hour program in which at least 2-3 cases used to be heard and decided. And I thought that perfect justice had been done to all those cases. My father also saw it, and he also felt that yes, perfect justice has been done in these cases. There is no reason why ordinary cases cannot be decided in this manner. Of course, that judge was a very intelligent judge. You can't find too many such people. But you see, about a judge, today we have this problem that we do not have enough courts. The law commissions have been saying this repeatedly, that we need many more courts, etc. And that is why we are faced with this delays and pendency of cases, etc. The judiciary, on the other hand, I have taken several such cases to court where 100 vacancies are advertised in the lower judicial service or in the higher judicial service. That means at the level of civil judge or at the level of district judge. And only 10 people are selected. And 90 of the seats remain vacant. Today in the lower judiciary, there are 40%, more than 40% vacancies even among the existing posts. In the high courts, there are 30% vacancies. Supreme Court, there aren't any vacancies, but in the high court, there are 30% vacancies. In the lower courts, there are 40% vacancies. And when I took these cases, and I said that, look, how can it be that 10,000 people apply, 1,000 people are shortlisted, meaning they qualify for the main exam. Among them, there are many who are toppers of their law schools, many who have even qualified for other judicial services in other states, and yet you have found them unfit. You have selected only 10 out of 100 people. How can it be? Obviously, there is some problem with your system of selection. To which the judges said, all these people had been failed in the written exam or in the interview, etc. The judges said, no, you don't understand. We don't find enough qualified people, enough worthy people to be appointed judges. Now the question is, what kind of person do you need to be appointed a judge? In my view, the main qualities that you need in a judge are, number one, he should have reasonable intelligence. Number two, he should have sound common sense. Number three, he should have a sense of equity and justice. And so far as legal knowledge is concerned, all that can be provided to him in 1 year in a good judicial training academy. In 1 year. So you select people, if you select people who have reasonably good intelligence, sound common sense, and a sense of equity and fairness, and then you give them training for 1 year, they will become, most of them will become reasonably good judges, reasonably good competent judges, at least for these Gram Nyayalayas, etc. Now, is there any shortage of such people in this country who have reasonable intelligence, sound common sense, and a sense of fairness and equity? There is no shortage. There is no reason why you cannot select more judges. Obviously, there is a problem with the system of selection. So, we need to set up these Gram Nyayalayas to provide access. We need to have more judges to speed up the process of disposal, etc. And we need to have competent and honest judges. Now, as I said, you can select competent judges if you have a proper examination to judge intelligence, common sense, and sense of fairness and equity. You can design such a test, kind of an aptitude test, which will test all these things. So there is no reason why you can't select good judges. The whole system of selection has somehow got, there are very, very serious problems in our system of selection. And then you need honesty. So you need to have a proper system of accountability for judges who become corrupt, etc. You need to have some institution which can, to whom complaints can be made and who can take action against these judges. So it is not that there are no solutions to the problem of judicial collapse as we are seeing today. There are solutions, but the problem is that neither the government nor, unfortunately, the sitting judiciary is interested in implementing these solutions. So therefore, how are these solutions going to be implemented? There has to be a people's movement. Just as there was a people's movement on the Lokpal issue against corruption, similarly, there needs to be a people's movement for judicial reforms. The judiciary is as important to the people as, or more important, in fact, than the issue of corruption. And in that movement, lawyers who really understand the system from within have to play a major role. And that is why I am saying that quite apart from keeping your eyes and ears open to what is happening in society, you need to also participate in whatever way you can to bring about these judicial reforms that are required. Now I come to this main subject of environment. So, you see, the problem with all of us know and understand that environment is a serious issue. It has become a serious problem because we have carried on development without having regard to environmental impacts of that development. What we are seeing is increasing air pollution, increasing water pollution, depletion of groundwater, depletion of mineral resources, rapid depletion of mineral resources. We are seeing global warming. All kinds of impacts are being felt, which were not bothered about by those who decided to do this kind of development. For a long time, there was not even a law which required the government or the authorities to examine environmental impact of projects before they were allowed. Finally, the Environment Protection Act came, and with that, some environmental regulation also came. Environmental impact assessment also started happening. But what we are seeing now is a reversal of all that which had happened. We are seeing gradually that environmental regulation is being dismantled. Despite the fact that we now know that the environmental regulator must be independent of the government. And the reason is, it is the government which normally proposes or allows certain development. The regulator which examines whether this development should be allowed or what are the costs of this kind of environmental costs of this kind of development, costs and consequences of this kind of development, cannot be a person controlled by the very same government which has proposed this development. Has to be independent. And the Supreme Court said that in a judgment many years ago. It's been now 15 years since that judgment where they said that we need to set up an independent environmental regulator in this country. And for 15 years that has not happened, with the result that the government sets up this environmental impact assessment body. And today that body has largely become a rubber stamp of the government. They are not examining. I'll give you a recent example in your vicinity, this Vihinjam port. I don't know how many of you are aware of this Vihinjam port. I have studied the matter in some detail. Now this port, because you have to make what is called a wall, it's a 3.5 kilometer long wall made perpendicular to the coastline in order to protect the ships which are coming in. Now the consequence of construction of this wall is that, and this is something which was stated in several scientific papers, including one authored by a scientist, what's his name? Anyway, some scientist of Kerala who authored several papers on impact of these walls on the beach on both sides. So what happens is, because there is shifting ocean currents, one season they go one way, the other season they come back another way. The wall construction, actually what it does is, it removes the sand from the northern end of the wall and deposits it on the southern end because of the nature of the ocean currents in this region. And therefore, because of the building of this wall which started in 2017 or so, we have been seeing, if you look at satellite pictures of the beaches around here, whether the main beach or the that Kovalam beach or the beaches even beyond that, you can see that on the northern side there is rapid, year after year, there is greater and greater erosion of the beach. The coastline has been coming inwards, and on the other side there is accretion of sand. Now, the same gentleman who had earlier, before this port came, Udale, who had authored several papers saying that the scientific papers saying that the construction of a wall leads to this effect, that on one side there is erosion, on the other side there is accretion of sand. He was now appointed by this government in a committee. When this matter went to court about the impact of this port and the sea wall, the court said, all right, you appoint an expert committee to look into it. When people complained that, look, now you can see that there is huge erosion on the north side of this wall and accretion on the south side. So the court said appoint a committee. Now the government appointed a committee headed by the same gentleman Kodale. Now we thought that he would remain consistent with his view that construction of a sea wall has this impact, at least in Kerala, because of the ocean currents. But this gentleman has turned totally around and he says, no, this erosion and accretion is not because of the construction of the wall. It is because of cyclone which came in 2017. It is because of global warming. Absolutely ridiculous things. Cyclone came and went in 2017. How can that cyclone have an effect after that, year after year after year? It's 2018, 2019, 2020, 21, 22, 23, 24. You see the satellite pictures, you see year after year after year, there is more and more erosion. How can the cyclone of 2017 affect this? Then he says global warming. Now, global warming will not happen only in Vihinjam or around here. Global warming is happening everywhere. So unfortunately, you see, what happens is when the government appoints these environmental regulators or these so-called experts and so on, they do what the government wants them to do. And that is why we need independent regulators. But there is a larger, deeper, more serious problem with environmental regulation. Now, if you take global warming, see, global warming is happening because of the rise of the levels of carbon dioxide or carbon in the atmosphere. Because in the last 100 years, we have burnt a lot of oil and coal and so on. Oil and coal, which was the year of millions of years of vegetative matter being trapped under the soil and it being converted into coal and oil. This is the product of millions of years. And we have burnt it all out or half of that in the last 100 years. We have consumed millions of years worth of vegetative decayed matter in a matter of 100 years. And the result is that there is so much buildup of carbon in the atmosphere that carbon causes this greenhouse effect and it is causing global warming. Now, every year or almost every year or every other year, there is an international meeting of all the countries to address this problem, and they come up with agreements, Kyoto Protocol, some other agreement, some Rio agreement and so on, in which they decide, all right, these are the targets, we need to reduce carbon emissions to this extent from up this year. By this year, we should have the carbon emissions down to 50% of present levels, then to 25% and so on. But this has been happening for the last 20 years. But we have seen no reduction. We are only seeing every year after year after year still an increase of carbon emissions. Why is this happening? Why are they not being able to comply with their own agreements? The reason is, you see, there are externalities. Unfortunately, there are externalities of development. And these externalities are really global in nature. That means, if I allow gas guzzling vehicles in this country, then the effect of that gas or petrol or diesel being burnt and the carbon being released is not merely being felt by us. By us it is minuscule. It is now spreading globally because this carbon buildup goes global. So there is, unfortunately, the world is divided into 200 sovereign nations. If the carbon emission and the resultant global warming was restricted to each country, then perhaps that country would have some incentive, some serious incentive to curb their carbon emissions when they see that this global warming is happening. But every country feels that, well, our carbon emissions will go all over. It will affect us only in a small way. It will affect the others as well. And every country feels that. So no country feels that there is any incentive to curb these carbon emissions because of the externalities of your domestic activity. And that is why I have always felt that either we require a world government which can rigidly enforce. You can't have these 180 sovereign nations each deciding what to do, what not to do. You either have a world government or we need some kind of artificial intelligence. This is just an aside. I wanted to just alert you about the developments that are taking place in artificial intelligence. You see, today, after this chat GPT-4 was launched, there is a lot of talk about what is called artificial general intelligence and artificial superintelligence, which may be coming soon. Artificial general intelligence means artificial intelligence which has multi-dimensional capability like humans, which can do all kinds of things and do them better than humans can do. Artificial superintelligence is an entity which is is not merely general intelligence, but it is so superior to human intelligence that it has the capability of taking control of the planet from humans. And I believe, my own personal view is that we are rapidly moving towards this artificial general intelligence and artificial superintelligence, and it is going, and these intelligences will be autonomous. They will not be under human control. They will modify their own programs, algorithms, etc., and therefore they will decide what they want to do rather than our deciding what they should do. So either we have a world government or we will have this artificial superintelligence which will eventually take over, take control of the planet, and in my view perhaps be able to deal with this problem by putting and enforcing regulations about use of carbon and so on. So environmental regulation, number one, requires that the regulator be completely independent of the government. And environmental regulation also requires that the decision-making body should be a global body and which should also be able to enforce its decisions. And that is why I say that this problem of carbon emissions is not going to be solved. We have seen it for the last 20 years. It is not being solved, and it will not be solved unless we have a global government. Global governments are needed for other reasons as well. Today, for example, Israel is committing genocide in Gaza. And unfortunately, because of the lack of a global government, despite the International Court of Justice saying that they are committing genocide, we are not being able to stop them because they say that we are a sovereign nation, we will do what we want. And unfortunately, the other country which could have stopped them, the US, it is also going along with them and doing whatever they want to do. So therefore, we need a global government for other reasons as well, but including for environmental regulation and enforcement of those regulations. Now, public interest litigation relating to environment. Lastly, I just wanted to touch on this. So there are certain environmental issues which can be taken to court, and some which the court will say, look, this is now eventually a matter of government policy, executive policy, and we are We can't substitute our own judgment over the judgment of the elected government. So what can be taken to court, what can't be taken to court? Firstly, I wanted to say that when you file a public interest case, firstly, you have to first think of what are you seeking from the court? What order do you want from the court? Suppose you want to tackle the problem of corruption and you say, okay, well, there is a huge problem of corruption in this country, court should pass an order to stop corruption. The court will say, okay, look, we can pass that order, but how will that help? Our passing an order to stop corruption is not going to stop corruption, just as all these agreements about global warming, they are not doing anything. So what do you want us to do specifically which will stop corruption? If you go to court saying that all right, you ensure that these anti-corruption agencies, as happened in that Vineet Narayan case or that Hawala case, the anti-corruption agencies which are investigating corruption like CBI should be free of government control, because these agencies are investigating the corruption of the government and therefore there is a conflict of interest. Therefore, unless they are free of government control, they will not be able to investigate high-level corruption of the government. So then the court can say, yes, all right, this is something which we can examine and we can do, which may effectively help in this dealing with this problem of corruption. So therefore, first duty of a public interest lawyer who wants to take a public interest matter to court is to very carefully think what is the order that you want to seek from the court. And then you have to find the legal basis for seeking that order. They will say, all right, you want us to do this, but tell me what is your right? Where does your right come from to seek such an order? So you have to then say, well, I am seeking the enforcement of this particular fundamental right. For example, the Supreme Court has held that Article 21 rights include the right to live a life of dignity, which includes the right to water, food, health, education, basic health, education, and a decent environment, and a corruption-free society. So therefore, you have to say, all right, this prayer arises from this particular right. I am seeking the enforcement of this right, due to which I am asking for this prayer. And then you have to ensure that you have the best possible information on this subject, that you have the best possible understanding of this subject. So you go and find out who are the experts, who are the people who have understood this issue, dealt with this issue. You reach out to them, you try and understand from them as to what needs to be done. For example, say this Wayanad tragedy. Now, if you want to file something, some public interest litigation on the Wayanad, around the Wayanad tragedy, where you want to say, all right, in order to prevent such tragedies in future, ABCD needs to be done by the government. What is that ABCD? For that, you will have to reach out to people like Dr. Kasturi Rangan, who gave that report, or other experts who have studied this issue. What is it? What kind of development which has been allowed, which should not have been allowed in these areas, which is leading to these tragedies? Because if you go to court with a half-baked petition, where you have either not formulated your prayer properly, or not found the correct or a good ground for approaching the court, or not consulted the relevant experts in order to understand this problem properly, then you are doing a great disservice not only to yourself but also to others who may later want to come to court or who may be wanting to come to court on the same issue but with proper homework. So you need, as public interest lawyers, you need to do your homework properly. So if you want to go to court on any environmental matter, you have to first decide what is the prayer that you want. What is the basis? Basis is given by the Supreme Court. All right, having a fair environment is part of Article 21 rights. And you have to consult the best experts. However, still there are certain issues where the court can interfere, certain issues where the court can't interfere. Suppose you go to say, look, this development was allowed, but the environmental consequences of this development have never been studied. Nobody has studied them in the government, and yet this development, which has enormous environmental consequences, has been allowed. So you stop this kind of development till the environmental consequences and the cost benefits have been studied by some body or some authority. In the Narmada Bachao Andolan case, there were, of course, several issues involved there. There was the issue of displacement. There was the issue of environment because it involved submerging a large amount of forest, etc. And there was this issue of costs and benefits. Now, one of the judges in that case in the early judgment, Justice Bharucha, held that, look, environmental impact studies have not been done. If they have not been done, how can you allow this project, this dam, to go forward without doing the environmental impact studies? So he said that you first do the environmental impact studies and only thereafter you can take this dam forward. But unfortunately, the majority view in that case, two of the other judges held that no, environmental studies can go along with the construction of the dam. To my mind, that was an absurd view. But unfortunately, the majority took that view, that the studies can be done along with the construction. Unless you understand what are the costs and consequences, environmental impacts and consequences, how can you go ahead with the raising of the dam? So, this is one ground on which the court can interfere, that is, to study the costs, benefits, etc. But suppose the government studies the environmental costs and says, look, yes, this does have some environmental cost, but it also has so much benefit because there is so much development taking place. For example, the Silver Line project, this rail line which was proposed for Kerala. Now, I have again studied this project. One of the greatest experts in the railways studied this. Dr. Sridharan also studied this. They all spoke against it, saying that this will cause havoc because you will have to build a new railway line through the ghats, etc. It will cause environmental havoc. But suppose the government comes and says, all right, we have looked at all the environmental consequences, etc., and we still decide that the benefit of having this railway line is worth the environmental cost, then what does the court do? Court can only say, look, you have not studied this, you have not looked at this properly, you have not done this properly, etc. The court can also say that, look, your expert committee report is absurd, like this gentleman who has given the report now on this Vihinjam project. His report is absurd. I mean, he's saying that this is because of cyclone and global warming, etc. Utterly absurd. So the court, sometimes the court says, look, we are not experts, we can't go into all this. But in my view, if the expert report is absurd, it doesn't make any logical sense, then the court can say and should say that this is an absurd report. And you either appoint other experts or we will appoint some independent experts to go into it. So, but if after looking at all the cost benefits, the government still comes to the conclusion that look, we still want to go ahead with this project because we feel that the development benefits are worth the costs, then in my view, the court can't substitute its own wisdom over the wisdom of the elected government. So then the court will have to throw up its hands and say, okay, look, we are not some people who can substitute our wisdom, even if we feel that this project should not go ahead. But if the government has considered everything and the government feels that it should still go ahead, then they can take it ahead. So those are some of the issues that I just wanted to flag before you. I hope that you have found whatever I have said of some use. Thank you very much.
Thank you, sir, for such an insightful and thought-provoking lecture. Now the floor is open for interaction. The students can ask questions and share their thoughts with the speaker.
Good afternoon, sir. Myself, Neetu Abraham, and my question is regarding. So, what are your thoughts?
Yeah.
Okay. So, what are your thoughts?
My God.
So, what are your thoughts on the role of social media in shaping the public opinion and also influencing the legal system?
No, I think the social media today plays a huge role. It's today actually more important than the mainstream media. And it's in a way good. I mean, it has its bad things as well. I mean, if you see that film called, there is a film on the impact of social media, a documentary which has been made, which points out that social media has led to greater polarization in society. And because the kind of algorithms that have been fed into the social media platforms, like if you go to YouTube, for example, and you start watching some particular kind of videos on YouTube, then the algorithm of YouTube will push and send you other videos of the same kind, with the result that you are being exposed to only one point of view. You don't get exposed to the other point of view. And that has resulted in greater polarization in society. So these are some of the bad consequences. But that film is called The Social Dilemma. It's a very good film. It's a very good documentary. It's available on Netflix or one of these platforms. But the good consequences of social media are that, for example, in this 2024 elections, there was the mainstream media which was completely controlled by the government, which was doing the government's propaganda. But fortunately, there was this social media or the alternate media on the internet, where there were a number of good journalists who had set up their own YouTube platforms or their own websites, etc., and who were doing real journalism. So, for example, people like Dhruv Rathi, Ravish Kumar, etc., they were doing real journalism and they were doing outstanding work. And it was largely as a result of this that we didn't quite see just the one-sided picture which the controlled media or the Godi media as it is called was presenting. So social media can also be misused by spreading a lot of fake news, etc. And unfortunately, we still do not have any proper and totally neutral artificial intelligence, which can, but we will soon have, which will be able to pick up by the use of that artificial intelligence what is true and what is false. It will go through everything, all the information that is available on that subject, and then be able to say, sometimes they may not be able to say for sure that this is false. They will say that probably this is false. There is a 90% likelihood that this is false, but we are still not sure. But we still don't have such a platform. And the result is that a lot of fake news is still being circulated through the social media, especially through WhatsApp, etc. But I think on the whole, the social media is a good thing. It has allowed good journalists, independent journalists to set up their own media platforms without having so much money. Otherwise, the mainstream media requires a lot of money. If you run a newspaper, television channel, etc., it's a lot of money is required.
So does public opinion really influence the judiciary in any way?
Yes, it does. Public opinion really influences the judiciary. And therefore, I have always been saying that if there is a good decision from the courts, you should praise it. If there is a bad decision, you should criticize it. That encourages good judges and discourages bad judges.
Thank you, sir.
Good afternoon, sir. Myself, Rachel. And one of the recent issue that is facing by the people in Kerala is regarding the decommission of Mullaperiyar Dam. So, if it decommission, it will affect the livelihood of people in Tamil Nadu. And if not, it will affect the lives of people in Kerala. So, what's the solution we can take over here?
So, you see, if there is a lot of evidence that the dam is in serious danger, or if we can show that the government has not studied it properly, or government experts have not studied it properly, the government appointed experts, or if we can show that the experts who have studied it have come to wrong conclusions, like this gentleman who has given the report on the Vihinjam port, etc., then we can go to court and say, look, there is serious danger of this dam breaking, which will cause havoc, etc. And therefore, to protect the Article 21 rights of the people living downstream of the dam, this dam needs to be decommissioned, irrespective of whether there is an agreement between Tamil Nadu and Kerala, etc. There may be an agreement, but that agreement will not trump the rights of the Article 21 rights of the downstream people. So either ultimately the government is also the Kerala government is probably feeling bound because of this earlier agreement between Tamil Nadu and Kerala regarding the sharing of waters, etc. But if they can get proper reports of experts, of proper experts, to say that this dam has become unsafe, then Kerala can certainly go to court, or even a public interest litigant can go to court, provided you have at least some good expert evidence to suggest that this has become unsafe.
Thank you, sir.
Sir, my name is Janaki. Sir, my question is, what is your opinion on the role of alternative dispute resolution mechanisms in reducing the multiplicity of cases in judiciary and for ensuring justice to the people, aggrieved people?
You see, today most alternative dispute resolution is in terrorem. Terrorem means you tell the person that, look, your case has been pending for the last 20 years. It will remain pending for the next 20 years unless you settle it. So you settle it in Lok Adalat. Otherwise, it will never get decided. So then the person says, all right, I will even take 10% of what I should be getting. Otherwise, I will get nothing for the next 20 years. This is called settlement in terrorem. You are terrorizing the people by telling them this judicial system will not deliver justice. Therefore, you settle. Or you are terrorizing them by saying that look, this judicial system will not give you justice, therefore go for arbitration. See, arbitration has become a very lucrative industry for retired judges. Today, retired judges are getting crores a year, crores through this arbitration system. Therefore, they have developed a vested interest in suggesting this kind of alternate dispute resolution. Vested interest in Lok Adalat and vested interest in, they don't want to set right the judicial system. They feel that people should feel terrorized to go outside this judicial system and give them crores by way of fees to these retired judges who do this arbitration or just settle outside in Lok Adalat. That's not the proper way of siding. And they are not interested. We have this PIL in the Supreme Court for so many years pending for the last 5 years regarding effectuating this Gram Nyayalayas. Nothing is moving on that. And on the other hand, you are holding Lok Adalats and you are holding, that is no way in my view of...
Thank you, sir.
Sir, my name is Nihal. I wanted to ask you about, when we think about the mainstream environmental law regime, that's specifically the international law regime, we think about Paris Agreement or the Kyoto Protocol. At least as of now, the Paris Agreement is happening. Now, all the COPs, they meet every year and they speak about things like INDs, Internet Nationally Determined Contributions, and they speak about in a positive sense that they are meeting all their INDCs. For example, in the last year when G20 happened, India boasted we achieved all our targets. But actually what is happening is we are achieving targets, but it's not actually making any impact, so as to say. So how to cut the threshold between achieving targets and actually making a difference?
Yeah, so it's like when you give permission to any company to cut forests, you impose this obligation on them, all right, you plant so many saplings. Now, whether those saplings survive or not, nobody knows. They just say, all right, we have cut 10,000 trees, we have planted 50,000 saplings. But those 50,000 saplings mean nothing. So the same way, when they say that they are meeting targets, they must be meeting it in the same way. By saying, look, we have planted so many... But the fact of the matter is that when you look at satellite pictures of the forests, etc., forests are disappearing. They are not regrowing or increasing, etc., because of this. It's all tokenism being done. So, of course, if it was properly enforced, and firstly, it has to be properly designed and then properly enforced. In order to, you can have, because if trees are planted which actually grow and which actually grow to a reasonable size, etc., you can have a situation where global warming is also reversed. You can reverse global warming because trees do sequester carbon. Today what is happening is that our net output of carbon is much more than the net input which is going in through trees.
Hi, sir. I'm Gifty. First of all, a big admirer of your work. I've known most of your work. I've known your work through the Deshbhakts, the channel, the YouTube channel. That's when I thought that, being a lawyer, you can also do good things for the society. So that's when I decided that maybe I can also do litigation and, to become a lawyer like you. I wanted to put forward that firstly. Now to come to my question. Yesterday it was a disappointing day for me because of several reasons, mainly because I caught up with the news after a long time. It's not a good thing, I know. So
you got what?
I caught up with, so I'm in the habit of regularly following the news. So there are mainly two YouTube channels that I watch, the Deshbhakt and Dhruvraj's YouTube channel. So yesterday I watched a few videos. One was on the RG Kar Medical College incident.
Yeah.
The second was Vinesh Phogat's story. I had closely followed the wrestlers' protest, and after Sanjay Singh's appointment as the president of the wrestlers,
Federation.
the WFI, Sakshi Malik, she retired from wrestling, and now after Vignesh Phogat's disqualification from the Olympics, she also declared her retirement. So I felt that the system is a failure. The system is disappointing us all the time, and nothing can be done. Was my feeling yesterday. It was, I had a lot of rage, but I didn't know what to do. Putting up a post on Instagram cannot help, but that's how I express my rage, by putting up certain posts on Instagram. So what is your response to that kind of disappointment that the system is giving us all the time?
No, that is true, that it's very difficult to really fight against the system and win against the system. But it is not impossible. So what has happened over the years is that the spirit of public activism has been dampened quite a bit, partly due to this government strong-arm tactics in clamping down on protests, movements, etc. This particular BJP government, I am talking about the central government, has taken various steps, including choking the funds of NGOs, etc., including imposing Article 144 to prevent any protests, including imprisoning many people, arresting many people, and so on. So that and the eventual denouement of the anti-corruption movement, of which I was also a part. I do not feel any now proud of being part of that movement. I feel very sad that I was part of a movement which has essentially collapsed and which brought this BJP Modi government to power, and which collapsed in a manner which has dampened public activism in the country. So a lot of the activists who came out for that movement have now just decided to sit at home and do nothing, which is a very unfortunate fallout of the collapse of that movement. So therefore, it's not that public activism cannot defeat the system, cannot achieve anything. It can and it will, but it requires a renewed. So when Phogat and Sakshi Malik fought, they were still fighting relatively a lone battle. The farmers supported them, but the general civil society did not come out so much in their support. So I know it's difficult. I know that there is a sense that we can't win against the system, but I think that's not true. We need to shed that defeatism. And now, fortunately, these kind of strong-arm tactics of the government, which it has been employing thus far to prevent any protests, activism, etc., even that will become less because of the loss of majority of this government. But that is a problem which we are seeing not just here, but it's also there in West Bengal, it's also there here in Kerala, etc., that these governments also do not want sort of major protests and so on. So therefore, this is a problem, but still I feel that it's not hopeless.
Thank you, sir.
Sir, afternoon. Sir, myself Adnan. Sir, you were talking about the irregularities in the judiciary of the Indian selection of the judicial officers, and the irregularities or the time-bound approach that a judiciary have to take in taking decisions. Sir, speaking of which, I'm talking about your professional career, sir. Sir, you are a person who dropped out BTech for a greater cause of becoming a lawyer, sir.
No, I didn't drop out for the greater cause, no. I had a very convoluted, it's a long story, but one of the reasons why I dropped out was because I was very homesick, because I had a 2-year-old sister at that time who I was very fond of. So,
But sir, but this decision has made a larger change in the Indian judiciary, sir, because of your presence. Sir, what made you to inhibit from the transition of Advocate Prashant Bhushan to Justice Prashant Bhushan, sir?
I'm not Justice Prashant Bhushan.
So what inhibited you? You could have, but in this course of time, you could have make a lot of landmark judgments regarding the environmental laws in this particular country, environmental problems in this particular country. Sir, for any advocate, it's up to the rule that you must convince the court regarding the law, regarding the facts of a particular case. But what if you become the court itself, sir? You could have make a powerful decision, sir. So why didn't you make?
I'm no God or anything. As I said, see, I have just kept my eyes and ears open, and I have a very wide interest. So when I mentioned artificial intelligence, that is also one of my areas of interest. I took up this case against COVID because COVID was also an area of my interest. So I took that case in the Supreme Court where vaccine mandates were struck down by the Supreme Court, etc. So I have just kept my eyes and ears open, and wherever I feel that there is, for example, now we are filing one petition. I don't know what would be the outcome of it, but tomorrow it will be filed regarding supply of arms by India to Israel during this ongoing genocide of Gaza, which we are saying is against international law, is against the Convention Against Genocide, which India has signed and ratified, because this amounts to aiding and abetting this genocide. So therefore, I just keep my eyes and ears open, and I intervene through the courts wherever I feel that there is a good legal ground for intervention, and where I feel that I have enough facts and understanding of the subject, then I intervene. Sometimes, occasionally, we succeed, as we succeeded in the electoral bonds case, but usually one doesn't succeed. Again, in this case, I don't know what the courts will do in this Israel supplying of arms to Israel case. I don't know what the courts will do, but I feel that we have a legally very good case. So therefore, I am moving. But it is not due to any grand design that I have. It's just...
Sir, I was speaking about a good judge could make good decisions, right, sir? You were talking about the irregularities in selection of a judicial officer, right, sir? Sir, but often it is said that powerful people can make places powerful, right, sir? So
powerful people can,
of course, make a place powerful, right? Or in what they are the job that they are designed upon. So, of course, making such good decisions and enforcing it to a particular entity, a willful or a wise judge has to be there, right, sir? So a person like you could have also done that. You could have also.
You are saying that I could have become a judge?
Yes, sir.
So, firstly, nobody would make me a judge. Secondly, I think I would not be a good judge, because in my view, see, to be a judge, you require what is called a judicial temperament, which means that you patiently hear one side, then you patiently hear the other side, then you weigh the things in your mind, and then you decide. I am more of an activist than a judge, meaning of course, I weigh things also, but when I feel that this is the right cause, then I go all out for that cause. So, in that way, I would probably not have made a very good judge, but quite apart from that, nobody would make me a judge. My brother was once offered judgeship, which he declined. Of course, my father was offered when he was very young, but I have never been offered.
Sir, one more. Sir, has MC Mehta inspired you at once, at any time?
No, he has never inspired me. He has never inspired me. Okay. Thank you. Okay.
So I'm Fazil. Earlier you were talking about setting up regulators to control these bodies.
Yeah.
So do you think these regulators will be independent, just like in the case of election commission? the body who was responsible for conducting free and fair elections are under control of the supreme leader, and he is under control of his owners like Adani, Ambani, etc. And do you really think setting up regulators is a good idea in this situation? And do you really think, is there any hope of free and fair election, at least in 2029? Like, um,
So, you see, the Supreme Court said in that appointment of election commissioners case, the Constitution bench said that if the government continues to appoint the election commission, then it is not likely to be independent. And therefore, we need to have a 3-member committee, Prime Minister, Leader of Opposition, and the Chief Justice of India to appoint the election commission. Of course, even that doesn't necessarily guarantee an independent election commission, because sometimes the Chief Justice just goes along with the Prime Minister. So that is also no guarantee. Nothing can be a guarantee. We can only create a system which has better chances of throwing up independent people. So for environmental regulator, we need somebody independent of the government. Now who will appoint that regulator, etc.? That will be an issue. But we can certainly have a system of selecting that regulator in a manner that it is likely to be more independent than a government appointed regulator.
so I want to ask you about the Lakshadweep situation.
Which situation?
Like the happenings in Lakshadweep in recent.
Lakshadweep.
Lakshadweep.
Yeah.
Lakshadweep Islands being bought by Adani and all the rumors.
I have not followed that very closely, so I can't.
Last word, please. Good afternoon, sir. What I would like to ask is, we have that ESG regime now, the ESG framework, the economic, the environmental, the social, and the governance framework, and under that you have the BRSR compliance, which should be done by the MSMEs, and then the listed companies can give it as as part of the annual report that is being filed. So the two questions that I would like to ask with regards to that is, what is your opinion with regards to that framework? How much is it being developed? And second is, now it's only focused on the MSME part and their compliance. How can we bring it down to the other areas or other areas? Like example, with regards to the Wayanad issue, there has been a talk on the major.
So let me tell you, this is not an issue that I have studied. When I say that I keep my eyes and ears open and I have wide interest, it doesn't mean that I know everything about everything. So I can't really answer that.
Yeah, so if it's, this is the last question, and it was a pleasure listening to you today. My question is with regard to the doctrine of manifest arbitrariness, which I understand has been used in the electoral bonds case. Do you think that is a doctrine that is necessary in a democracy which sometimes turns up super majority governments? Your own thoughts on it, since you might have argued it in court also. Thank you.
No, I didn't really argue manifest arbitrariness. I had said primarily that this is firstly against the people's right to information, to be informed about who is funding these parties. Secondly, it will promote corruption, as we have found that it has done, because most of the bonds were given for quid pro quo. And thirdly, it will derail democracy by making the uneven playing field even more uneven, because most of these bonds will only go to ruling parties, as they did. Almost all the bonds half went to the BJP, which was ruling at the center and in some states, and the remaining half went to other ruling parties in the states. So the parties which are not ruling parties, they will not get anything at all by way of electoral bonds, because since most of these bonds are being given for quid pro quo, therefore, So that were my arguments. Manifest arbitrariness was probably either argued by somebody else, or maybe the judges themselves said that. The manifest arbitrariness is a somewhat subjective thing, and it's not, it can become totally subjective as to what is manifestly arbitrary or not. I'm not saying that that necessarily is a bad doctrine to have or to adopt, but it's a tricky thing because it can easily make it judge centric. So judges, for example, are reluctant to substitute their own wisdom over the wisdom of the executive, which is the right policy. If it's only a question of deciding the cost benefits as to what you are willing to forego for what development, etc., then yes, judge should not substitute his own wisdom. He should only ensure that everything has been seen by the government. All aspects have been examined, and not examined in a stupid way like this man who says that this is global warming, etc. So, same way, manifest arbitrariness is a doctrine which should be rarely used by the judiciary, but it can be used. I'm not saying it cannot be used, but should be rarely used. Thank you.
Thank you, sir. I now request Director Father Joseph Venmanat to present the memento to the guest as a token of our gratitude. Thank you, Father. Thank you, sir. I now invite Dr. Thomas Kutty PG, Coordinator of Dr. N.R. Madhava Menon Chair on Legal Education and Academic Advisor of Mar Gregorios College of Law, to deliver the vote of thanks.
More comfortable now. Adv.Prashant Bhushan ji, dear Director, Advocate Father Joseph Venmanat, dear Principal Dr. P.C. John, Finance Director, Reverend Father Adarsh Kumbalat, Vice Principals Professor Ushakumari and Dr. Ramendran Nair, faculty members, my dear student friends and guests. Namaste. It is with great pleasure that I stand before you to deliver this vote of thanks after such an enlightening and thought-provoking public law lecture on governance, environmental sustainability, and the development trade-offs. This intellectual banquet was truly a befitting tribute to the Most Reverend Dr. Benedict Mar Gregorios of revered memory, who was a champion for environmental protection and sustainable development. Being a first-rank holder in his postgraduate degree in economics from Madras University, he translated his profound knowledge in economics for the cause of the poor, the marginalized, dispossessed, and the voiceless, for whom he was commissioned by his master, Jesus Christ. I would like to extend my deepest gratitude to our distinguished speaker, Adv.Prashant Bhushan ji. Sir, your expertise, insight, and eloquence presentation has indeed broadened our perception and understanding. The words from your heart is of a true soldier of environmental sustainability have given us much to reflect upon, discuss further, and act. Dear sir, Mar Gregorios College of Law community is deeply indebted to you, and please accept our sincere thanks. This public law lecture was made possible because of magnanimity of my two good friends, Mr. Thomas Lawrence, the CEO of Wetlands International, and Professor Godwin VP, coordinator of Christ University, Trivandrum Center. Mr. Thomas Lawrence is alumnus of Marivanus College, and Godwin is my beloved student at Marivanus College. Thanks a lot, dear friends. It is my duty to extend formal words of gratitude to our Director, Father Advocate Joseph Vanmanath, the chairman of this session, for his guidance and leadership. Thank you, dear Father. Thanks are due to Principal Dr. P.C. John for all the support and for delivering the welcome address. Thank you, sir. A special word of thanks to our Finance Director, Reverend Father Adarsh Kumbalat, for all the support extended for this program. I place on record my indebtedness to Vice Principals Professor Ramindran Nair and Professor Usha Kumari, and also all the faculty members and support staff. It's a matter of pride for me to acknowledge the presence and involvement of my young student friends. You are here in spite of the holiday, reflects your craving for intellectual pursuits and concern for local socio-legal issues. Thanks a lot, my dear children. I duly acknowledge and appreciate the presence of Dr. Jacob Vadakancheri and Advocate Varun G. Nayan. Thanks, you, sirs. Today, we have with us friends from legal fraternity, faculty from other higher education institutions. Thanks a lot for you all. I thank the collaborators of this program who has worked tirelessly behind the scene. Thank you for ensuring the smooth running of this event. Your dedication has made this lecture not only possible, but a resounding success. Special thanks to the MC Janaki Jayaraj and core members Fiba Mariam and Prisha Mathu. I must thank Professor Ria John, Associate Coordinator of Dr. N.R. Madhava Menon Chair on Legal Education, GREGORIOS College of Law, for her meticulous service to organize this program. Thank you, Ria teacher. Finally, let us not leave this hall with just knowledge we gain, but the commitment to apply it in our respective fields. Let us continue to engage, question, and explore the vital issues raised today. Once again, thank you all for your presence and participation. We look forward to more such enriching sessions in the future. May God bless us all. Jai Hind.
Thank you, sir, for your words. Now, I request everyone to rise for the national anthem.
जनगण मन अधिनायक जय हे भारत भाग्य विधाता पंजाब सिंध गुजरात मराठा द्राविड उत्कल बंगा विंध्य हिमाचल यमुना गंगा उच्चल जलधि तरंगा तब शुभ नामे जागे तब शुभ आशीष मागे गाहे तब जय गाथा जनगण मंगलदायक जय हे भारत भाग्य विधाता जय हे जय हे जय हे जय 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 हे.
Thank you all for attending. Thank you all for attending the public law lecture series. We hope you found today's session enriching and enlightening. Have a wonderful day ahead.